Thank you so much for coming. And this is going to be an awesome session for CLEs. We have both John Morris and His Honor, Judge.
Judge Mike McCarthy, not the coach at Dallas. My cousin.
To help us to figure out, and we're recording today simply because we might be able to put this on our website that people that weren't able to come today, we put passwords in. We are allowed to produce these by the PA CLE board. We got approved last June to do Zoom CLEs, but live is important since they changed the requirements back. So please join me in welcoming the judge and John and are caught on camera. I'll leave it to you.
We end up, as Lori said, we are here to present probably a unique CLE. I'll give a bio of each one of us. Judge McCarthy joined our team, myself and Jay Volker and Chuck Volker from Volker, Carries and Morris, developed a CLE due to our practice in family law and the cell phone usage now that's kind of become every day, every minute in our society. So unbeknownst to us, when we grabbed the Honorable McCarthy to speak at Robert Morris with us in February, he'll explain to you stuff I didn't know that he was versed in with the Wiretap Act, and being on the bench, he knows and is able to apply certain aspects. We did give you a handout. We'll give you a little bio. I'm John Morris. I'm with Volker, Carries and Morris. I've been practicing over 32 years. Prior to that, I was 20 years as a judicial law clerk, and I had a sole practice. That was with Judge O'Reilly and Judge Avashovic. I left there and went back into the private sector, and I've joined the Volker Carries team, now Volker, Carries and Morris. We concentrate in family law, estate law, and a little bit of civil litigation. And the handout we gave you didn't have our bios in it. I apologize, but Chuck and Jonathan Volker weren't able to come today. They had another court commitment that I don't think they can get out of. So you're stuck with me and Judge McCarthy. We'll take a break somewhere in here. We're going to mold ethics into this a little bit as well. So we won't say the first 2 hours are substantive and the last is ethics. It's kind of rolled together. So, and we'd be open to questions from everybody. We know a few people that are online, and feel free to ask any questions. We'll take a break probably after the first hour and 10 minutes. I'll let Judge McCarthy give a little intro.
So I am Judge Michael McCarthy. I am currently in the Orphans Court Division. I started out upon being elected in the Civil Division, which I was put into by Judge Anthony Weddick. He recommended me based on my work in the Board of Viewers, doing tax work and things like that. And, but my background is kind of interesting to the extent that I started out in the United States Navy Seabees, combat engineers, and I was young and dumb. And it was 1971. That's maybe before we had colored TV everywhere. And so,
Seat if you'd like.
no, I'm good.
You're
I
cutting
can
your head off.
cut my head off.
Marie Antoinette.
It's the only asset I had. So I became a Navy Seabee, which is a combat engineer. I was assigned to a Seabee team and I was deployed to Vietnam. I spent a year in Vietnam studying Southeast Asian history. I learned to build and blow up. So whatever you desire I can do in that aspect. When I came back, as I say, when I went, I might have been young and dumb, but I came back and I matriculated at Duquesne University. And my matriculation was interesting because I became an English major, literature, and I loved to read, so I kept reading. And I was recruited out of a bar called Frank and Wally's by Dan McCann, who just passed away, our coach, to play on the football team. And so in 1973, we went undefeated, and I'm in the Sports Hall of Fame at Duquesne, which is bizarre in and of itself, however. So when I got out of undergraduate school, I took the county police test and I passed that. And I also was the district attorney, then District Attorney Colville, was starting an investigative unit. And there's a specialty in that unit. Michael Riley was the first assistant, and they had just passed the Wiretap Act, Chapter 57 in Pennsylvania. Since I was a Navy CB and knew how to climb 40-foot telephone poles, I fit the bill. And so they hired me first, and I became an undercover police officer in Allegheny County. And I was head of the wiretap unit, which consisted of me. But so I would order myself around and things like that, try to be important. And so what happened, it evolved into us interfacing with the state police, with ATF, with narcotics officers, with the city, with the county. And so we created a wiretap team, which then, and this was in the late 70s, was utilized to do court-authorized wiretaps. So that in the beginning, the wiretaps were very restrictive. Chapter 57 had a very specific design for court-ordered wiretaps. You had to have probable cause. You had to prepare affidavits. To be a certified wiretapper, there were two areas. You were A, certified, which means you could monitor a case, and B, certified, which means you can be the guy climbing the pole. My B number was 57, and there were 25 state troopers in the first class, so I was in the second class. So I was certified to do wiretaps and learned a lot about how to bridge and hook up phones. In the course of that, I had an opportunity to testify in court. And one thing I noticed in court, bad lawyers. I thought I could do this. So somehow, before the restrictions were even tighter, they let me into law school. And I went to Duquesne at night for 4 years while I was working as a police officer, which was interesting. And so I would go to class at night. Unless there was a wire, sometimes I got tied up because I always tried to take the midnight to 8 shift because class was from 6 to 9, and sometimes I'd miss class. My hair was long. I had an undercover car. I had overtime. It was great. And then I had another thing called Mara McCarthy. My wife and I had a child, and my wife has this great picture of me holding Mara as a baby in a chair, and I'm reading her the Uniform Commercial Code, and we're both sleeping. Dead on. So if you know anything about the code, you know that that could put anyone to sleep. So upon completion of law school, Mr. Chris Capitas and Mr. Colville decided, they told me they were going to hire me because I knew what the drugs were. I knew where to stand. I was a combat veteran, so I wouldn't get rattled. And I got hired as a DA. And I worked in that capacity for about maybe 13, 14 months. And then I had an opportunity because Judge Green broke up the phone company into 7 RBOCs. They were regional phone companies. And what happened is the regional phone company, Bell Atlantic, wanted to hire lawyers. And so another police detective magistrate hired me here in Pittsburgh at the Bell Atlantic. Don't hurt yourself.
We're trying to get it low, because I'm
At
sure.
Bell Atlantic, in the risk management department. Now, Bob Minard was the person that hired me. And you may remember his name because he did homicides and things like that. So then I became a legal advisor, worked for Bell Atlantic for a couple of years. And one day I was flying back from Philadelphia and I found out that I was just about to be transferred to Philadelphia. And we had our second daughter, Caitlin, and all due respect, I didn't want to go to Philadelphia. So I'm sitting next to Barney McGinley, whose room I worked as a DA, and Barney told me that Judge Murphy, or David Ward Murphy, just got promoted from the Board of Viewers to the bench, appointed, and there's an opening. I applied, and the judges appoint the masters, and I became a master at the Board of Viewers, which then gave me an opportunity to act with a lot of pro se and get a sense of how to handle cases. And sometimes property tax appeals can be very difficult. Sometimes they can be very easy. But all in all, and people come in scared, they're not necessarily always represented. And I did that for years and years and years. I ran for judge twice for sure. Lost once, won one, and became a judge. And as I said, I was assigned, interestingly enough, right into the civil division. And Judge James, Joe James, was the president judge. And at that time, he asked me, how is it that Tony Weddick at a meeting said so many nice things about you, and he requested you come to the civil division? I said, well, I don't know, Joe, but I have pictures of him reading comic books. And if you know anything about Judge Weddick, you know he was a great intellectual, and no one still knows to this day why he said he wanted me. So I went into there later, about 8 or 9 years. I got a call from a justice in the Supreme Court and said, I'm going to send you into family division and you need to clean up a docket. So I was in family division for 8 months, 2 days, 6 hours, and 20 minutes. Not
You
that,
still count that.
not the family division isn't an interesting place, but it was. And I got experience there. Went back to civil. I did mostly medical malpractice cases. And eventually, 4 years ago now, transferred into orphans court, which is, as they say, hog heaven. It's on the 17th floor of the Frick building. It's nice. The only people that complain and yell and scream are beneficiaries. I should have got it, you didn't, blah, blah, blah. So that's my story of how I got here. And that's sort of my resume before we get into the details of the wiretap. But that's me, and I guess I can't change it.
No, you can't. No, it's, I hope we make this more lively for you, because I know the judge would bring it to you, because I don't know if any of you have ever appeared in front of him. And I remember him in his days in family division, because I was a law clerk still with Judge Abashovic and would run into him there. After Judge O'Reilly's in between there, he pulled me in to help with the mortgage foreclosure program. You forgot to do that. You were one of the mainstays and foundations of the county mortgage foreclosure program. And that was pretty tedious. But one thing you reminded me of, Judge, a few years ago, I appeared in front of you. I was running for magistrate, and I had a hearing the same day of the primary. I don't know if you remember this. So I came in, I had a simple motion for continuance unopposed by the other side. So he has the audacity or the his little humor, which I find pretty unique. He looks, he says, I'm thinking he's got to grant this. He knows about out of the, if you remember what you said, he says, because I didn't put the reason. I said, I'm not available, conflict in the schedule. And he said, I guess running for magistrate was a good excuse for a continuance. And he had the courtroom laughing. And I didn't know what to say at that point because I know I didn't write it in the motion. But if you want to appear in front of members of the bar that were once us that are knowledgeable, he's one guy you want to get in front of. He's practical, he's knowledgeable, he knows the background, and he's surprised Jay and I at the thing at RMU so much so that when I came back to the office, said, Chuck says you better tell the judge he's made a lifetime commitment. So he's committed to this anyway. But anyway, let's get on to some of the materials we gave you. I'll give a little bit of the history, and it's printed in here, but I found something the other day. I was reading the Post-Gazette, and I thought it was a little bit helpful. May 24th, which was Monday, was the anniversary of a unique day in our country. May 24th, and I looked it up, May 24th of 1844, and I found the U.S. Senate's communication document back then, and this is what it looked like back in 1844. If you want to see a copy, I just was able to print it today. But back then, there was a request in the 1830s for construction of telegraphing in the United States as a form of communication. And what drew that about, I found out some of the history, is the lobbyists coming to Congress had to travel, wait on newspapers. So they were putting together, as any innovator would want, some means of communication between people, especially a country that was growing. They appropriated $30,000 back then to construct a 50-mile line from Washington to Baltimore. Judge is nodding. I don't think you were around in the 1840s, but
I read it.
so all right. So in April of 1844, we all know him, Samuel Morse set up a laboratory, and back then the Supreme Court's chambers were across the hall in the Senate, one of the Senate's wings. And on May 24th, which had its anniversary 2 weeks ago, or 2 days ago, he gathered a group in those chambers and he sent the first message all the way to Baltimore. And on the other end of the line was his partner, but the message was put in his head to telegraph by his daughter. Does anyone know? And it's not the Watson one. Does anyone know what Samuel Morse telegraphed? I heard it, and this reminded me of it.
What terrible wrath.
Wow, you've got it pretty much on point. What hath God wrought was the first communications in our country, and it was done by a telegraph. And then he got a response back. We don't know what the response was from Baltimore, suggesting that the lines worked. So the advent of communication remotely, not in person, started back then. And you must have been around there because you must have been around at that time. You remembered the time, Judge. So anyway, I'm not gonna read from our pamphlet because we kind of like to improvise and make it accessible. Feel free to ask any questions if you have. But the first 2 or 3 pages of our handout, I felt as we developed this program, and I looked around for CLE courses throughout the state, and I haven't seen one on cell phone usage. There might be others, but this would be our 3rd or 4th time presenting it, and the library asked us to come back with it. Because I'm sure in all our practices now, the cell phone is the main tool that has evolved over time. Well, as you'll see in the handout, right after Samuel Morse in 1844, there was people, innovators, inventionists, whatever you want to call them, trying to develop another device where you could talk. And I don't think it even had the terminology then, but it eventually evolved into it. But what I found funny, and you'll see it in your materials, in 1876, there was two people competing for it. There was a woman by the name of Alicia Gray, and of course, Bell himself. You all know Alexander Graham Bell. And for those that don't have the materials, on March 7th of 1876, he was granted a permit, and that is what the phone looked like back in 1876. And again, everyone should know his famous quote, "Mr. Watson, come here. I want to see you." So we have two unique things back in the mid-1800s where our society wanted to, instead of probably newspapers and the written word, wanted verbal communications. So you'll also see in the material, the White House had a phone installed, and it was 1877, and it was Rutherford B. Hayes. Without looking into materials, do you know what phone number was assigned to that? You know, because you know the material. I thought number one was assigned to that. And then it took 50 years later for President Hoover to install an official phone in the White House at his desk. And that's depicted in the materials there. Now, I also found interesting in doing some of the history in the background, you'll see on page 3 of the material, and I found the newspaper clipping back in 1953 from the Tacoma News Tribune. There was an article called "There'll Be No Escape in Future from Telephones." And there was a San Francisco director of the Pacific Bell, just summarizing what he did. And he had, kind of like being a prophet, he stated, and they quoted, "Just what form the future telephone will take is, of course, pure speculation. But here's my prophecy. In its final development, the telephone will be carried about by the individual, perhaps as we carry a watch today." And who can imagine that now? We have phones on our wrists. It probably will require no dial or equivalent, and I think the users will be able to see each other if they want to talk. Who knows but what it may actually translate from one language to another. Imagine that prediction, and this was the newspaper article back in 53.
I can't imagine it. I was only 3 years old.
He has to get the ages, you see. I'll probably hear about the 1800s from you. Thanks. So he's going to chime in a little bit, because when I bring you up in time from the 50s, Cooper is the man termed the father of the cell phone. And well, before we get to that, let me go back to page 3. You'll see what some of the phones look like throughout our time. Does anyone in here remember what a payphone is? Some of us older ones do. You in the back haven't really had the privilege of going corner to corner and seeing payphones just about on every corner. I grew up in Scranton. I was born and raised there, and I moved here in 82. And I stayed here and went on to law school and kept my roots here, but my family's back there. Back in the 70s, and then you young ones might know what I'm going to say. I didn't realize I said it then, but Jay caught me at an RMU thing of saying something that young people that I didn't know knew. Back then, our first grade teacher had a dime on every desk. And we walked in and said, "What's that for?" The first day of class. She says, "You're going to carry this in your wallet." And there was a special envelope. And she had on it payphone. Back then, it was 10 cents to make a phone call. So what I said in RMU, to bring some humor to this, I told this young class that my cell phone was a dime that I carried in my pocket. And I didn't realize that that's slang for drugs or whatever. You're nodding your head. Well, Jay's over there laughing. kept his head down, and I didn't realize it. He texted our office and said, John's telling him that he carries dimes in his pants.
Dime bag.
A dime bag, yeah, that's right, Judge. So I didn't realize the look I got from the college students, and it realized how history, things change. My daughter didn't know what a beta was or a 8-track player, so I didn't know that. So I went along with the whole thing till we broke, and then someone finally realized. Jay said, you better tell them what the dime meant. So I'm giving the whole story. We go to class, we have a dime on our desk, not a baggie, but a dime. And just about on every other corner, there was a payphone in the city of Scranton. I'm sure it was here in Pittsburgh. Nowadays, as we grew up and I would go to New York City and visit family, you didn't want to touch some of these things. They were, talk about COVID, these things had all kinds of disease and germs on it. But anyway, that's depicted on page 3. And I had to tell the students at RMU, that's where you use the dime, even though it says 25 cents, because it went up. So bringing you full current, to the current, in the 70s, I believe it was, that this, his name was Mark Sullivan's prophecy came true. April 3rd of 73, Martin Cooper from Bell Labs made the first prototype Motorola phone. And the person he had helping him with it, I guess the guy's name was Joel. His statement was, Joel, this is Marty Cooper. I'm calling you from a cellular phone, but a real cellular phone, a handheld portable cellular phone. Hence, he got the name of the modern day creator of the cell phone. So not only have Morse code, Morse for the Morse code, you have Alexander Graham Bell for the institution of the phone, and the cell phone from Cooper. And I don't even know if he's still alive, Judge. I'm not sure. Anyway, the phone, and I'll let him talk. He uses the word, and I won't use it, but it was this big, and it had 20 minutes of battery life. So, and it took, and I don't even know if I quoted it right. It weighed, yeah, I did. It weighed 2.2 pounds. So I guess nowadays that would be way too heavy to carry. So that was it. And your term, as they called it,
The brick.
the brick. So it was the brick. Can you imagine walking into court today with that? You'd have a separate briefcase for it. But at that time, now you have the handheld, which is what we all seem to carry. But another thing I forgot to mention, it's in your material, we also had pagers. Before we got the flip phones and the others, you carried a pager with you. And when I was Judge O'Reilly's law clerk, that was the way he got a hold of me. And I'd find a payphone, I'd pull in off my car, what do you need? Then I get back in my car. Well, eventually I got the gray flip phone, which gave you a little bit more battery life. But again, charging took forever on those things. So the evolution of the phone that we have today has fulfilled a lot of prophecies about our society as we've evolved. I think we'd all be naked if we didn't have this with us today. And a lot of people get upset if they lose it. Now there's a variety of things that can happen, and we'll get into it about hacking and how this thing could be a good tool or it could be a bad tool in the hands of the right person. I'll get into some more of the court stuff, but does anyone have anything they want to add to any of the history aspect? So we get the history of how we got this and now we're dealing with it in court. I do recall in the early 80s and 90s when we were in courtrooms, you had the videos that would come in. If someone took a camcorder video, whatever, and you might know the guy, it was Les Banos. Les was a little shorter than me, and he was the photographer for the Pittsburgh Pirates for Roberto Clemente. Good friends with Roberto. In fact, I got to know him, and he took the last picture of Roberto hitting his 3,000th hit. Correct. And he golfed with Roberto. In fact, he was supposed to be on that trip where Roberto perished, but because the Steelers made it to the playoffs, he was required to be back in Pittsburgh to take photos for that. So if anyone in court, I know we have some older men here. Did you ever have to call Les Banos to come do the videos? Never had? Did you ever have to do that? Did he ever come in your courtroom?
Not that I'm aware of.
Okay. Yeah. Well, he was short. You might not have seen him, but that's how you got some of the evidence in. were videos. If you had someone using a camcorder and they were watching somebody, and we're going to get into how that evidence would come in, and it's in your materials, how you get to the point of getting evidence of video and cell phones in. And the right way in front of some judges, some that aren't so knowledgeable of it, and some that are. And I'll get into something later where I had to write a brief for a case in Westmoreland County based on some of the materials we're going to get into about the use of the phone. So following the material, I believe on page 5, we talk about, I'm going back and forth, about video recording evidence if it's demonstrative. And it comes from the case of Commonwealth versus Surge at 869 Atlantic 2nd, 1170. Video recording is demonstrative if 3 things happen. It's properly authenticated pursuant to the rule of evidence 901 is fair and accurate representation. 2, it is relevant pursuant to the rules of evidence 401 and 402. And 3, most importantly, its probative value has a probative value that is not outweighed by the danger of unfair prejudice. And I'll bring a case in point. I was clerking for Judge O'Reilly, and we had a personal injury case. And the plaintiff was alleging that he couldn't use his hands anymore as a result of some injury. I got called in to watch some stuff when the lawyers took a break. The judge asked me to go out. They had a defense video, and Les Vanos brought in the video and put it on the screen. And all the questions before that they asked of the plaintiff, can you use your hand? No, I can't even carry bags around. Can you check the mail? No. Can you go grocery shopping? No, I have trouble using my hands and material. Well, wouldn't you know, when that was the defense crossing him. At the break, they had a video that was subject to these rules, whether or not it was going to get in. And the video showed him going to his mailbox, pulling the mailbox down, grabbing the mail, carrying another bag. Another video showed him opening the trunk, pulled out 3 bags of groceries, carried them up, came around. He was mowing the lawn. There was a variety of things. So to keep the judge out of it, I was there as the law clerk watching it, the 2 lawyers. About 3 hours after they saw that, we didn't get back on the bench, they settled the case. So if you're good at cross-examining and you follow the right rules, you're going to get in videos. Now, you'll see you can't necessarily get in audio. That I know, Judge, you will talk about that. Audio can be a gray area, and I'm sure it'll still be a gray area. It might change, but the videos you definitely could get in if it meets all those criteria. Okay, so we're up to that part of getting this in as evidence, and we'll get into something further. Judge, do you want to step in then about that gray area or anything else I may have missed? Be careful, he's grabbing a book now too.
The book is demonstrative. This is kind of like what the cell phone first looked like. It's about this weight. It's about this size, at least the width of my hand, and it was called a brick. And folks had the brick initially, and you've probably seen pictures of it. And with that, that was the first cell phone. So one of the things that we have to look at is from the perspective, in my opinion, as the Chapter 57, the Wiretap Act, the law. Are you related to the Moores?
No, that's M-O-R-C. He spells it the wrong way.
I just wanted to make sure. So the act was passed, and Michael J. Riley, who's an attorney here in Pittsburgh, was the first assistant DA. And our original Pennsylvania Wiretap Act was modeled after the New Jersey Wiretap Act. So the state act is different than the federal act, but there's a lot of similarities with that. And so once the act was passed, the question becomes expectation of privacy. What kind of privacy? That privacy that you're looking for when you have a phone. The way the act was created and started from the kernel that grew into the tree of the wiretap was, you did have an expectation of privacy. Therefore, the police had to have probable cause to tap your phone. And so that created a whole practice amongst the police who were using the Wiretap Act initially to tap this new technology that was going around, not just cell phones, but hardline phones. Like, if your number was Churchill 1212 back in the day, you had a hard wire, and that's where the police would try to tap your phone based on probable cause. That's where I came in, as climbing the pole and bridging the wires. So you had to have knowledge of the phone, you had to have knowledge of how to climb. And as a police officer, you had to have knowledge of probable cause, because you had an initial expectation of privacy. And with that, you had to produce several items for the court to decide whether or not you could tap phones. So initially, when we looked at the wiretap, when you look at the Wiretap Act, there was one party consent, and that usually was the state. The state would give in the state statutes one party consent, where one party could approve. If there was a wiretap and there was no consent, then that required a warrant, which means you had to put a warrant together to get that. And also, what developed was cell phone surveillance, which really became more important later. But in the late 70s, early 80s, the evidence of the wiretap was important. And when you look at these wiretap laws in the beginning, there was a third party secretly monitors communications in order to investigate an involved party. And that was sort of the mantra that was taught at the State Police Academy to the certified agents who had to be certified as the statute so states. So not every police officer could do a wiretap. And that wiretap was given by a court with a court order. So it was very specific. And so we had to develop techniques to get to the point of presenting through the DA or the Attorney General the application for the warrant. So there's things like applying for the wiretap, requirement of a statement of facts. So let's say we're working on a narcotics case. You have to have a reason to tap this particular phone. And one of the reasons is you had what we call a snitch who would call this number and then buy dope. In the old days, the late 70s, it was a nickel bag. Then it grew to a dime bag, so you know the difference if you're looking at the dope you're buying. So that statement of fact was memorialized, and their use of investigative techniques, trying to infiltrate the distributor of these drugs. And there was a time when you had to try and fail to enter into the criminal organization. All of this had to be put together in bullet points. So the DA and the judge, when the DA went to the judge, anticipating the judge's question, because the judge is going to say, why do you want to tap Mike McCarthy's phone? Well, we believe, and again, we get back to that probable cause. So the Wiretap Act was a very interesting act. At least I found it interesting living through the evolution of it. It was really a scale, balancing your rights with the fact that you're looking for information that's leading to a criminal investigation that would cause someone to be indicted and perhaps, go to jail. the reason I explain it that way, and they're sort of simplified steps, but this sort of takes the fabric of the law, which is what the law looks for, that balance of your rights versus the crimes that you may be involved in committing. So you also had to put together in your affidavit whether or not you've applied for a wiretap in the past. And if it was rejected, why? Because the court needed to know. And that's another very important problem that some prosecutors as well as police officers might have forgot, because you got to tell the judge what you're there for, what you're praying for, and all of the facts. Now, interestingly enough, I just had a case where someone forgot to tell me that another judge refused this petition. And as I said to counsel, don't you think that's important? And counsel said, well, not well, that's a hole in the ground. Don't fall in it. It is important because I may grant your prayer, but I need to know that a judge denied it. And you can tell me the best guess you have as to why, but I think that's important. The scrutiny that I put on this petition was ratcheted up to 80 points by that, by that. So again, when you're looking at a case as defense lawyers or even as prosecutors, these are the kinds of things that you have to put one after the other as you climb that ladder. And it becomes very interesting because post-arrest, this wiretap that you've done might be critical in a suppression hearing, because all that, fruit from that poison tree, that gets thrown out. And as a DA, I can tell you that there's nothing worse than having a police agency come in with a case that's, yeah, it's a bad guy, but I can't prove it, which then begot what my wife watches all the time, all these drama shows about there's the police and then there's the prosecution, and that interface is actually a good thing, I think, but it's interesting. So you really have to exhaust all of your efforts and show the court that there's no other way. And some of the examples that I recall from my experiences were, for an example, I developed, they called me Garbage Mike, because I would try to go through the garbage and you'd be shocked at what you would find in a garbage. And at a suppression hearing, there was no expectation of privacy. So in doing a case involving gambling or white collar crime or other things, if you have access to that garbage, there's no expectation. And we used to find pink slips and stack them up. And if they were high, that means that's someone who got ripped off because they want their money. And then you called that person and they'd say, yeah, he stole money from me. And so now you had another victim to add, and you can show the court that I've been due and diligent in trying to do other things. I don't know what was said. I don't know how it was being said, but if we had a phone tap on it, we could play the tape because it's usually a solicitation of some point. There's physical surveillance that you should do, especially in a drug case. You sit there, you set up, and your surveillance team watches traffic. You then start trying to get a buy-in, either a police officer undercover or a confidential informant, AKA snitch, would go in and make a buy and say, look, I called this number, I went there, and I got a nickel bag. And if it was in the 80s, it was a dime bag. But okay.
I was in the 80s. That's
Yeah,
right.
he was in the 80s. And that's where confidential informants can help. But really, if it's a distribution case, you want to have the wire. There's tracking devices that you can put on cars, which is part of the act, but not as important. And there's trackings. So once you exhaust that requirement and you get the approval, the wires are usually 30 days with a 30-day extension. The court signs it, and you have an obligation, usually within 10 or 15 days, to report back to the court. How's it going? Once you get set up and hooked, and once I climb the pole and get the bridge to a location, an LP, a listening post, you put what they call a pen register on the phone. A pen register registers all the calls outbound. And now, because of the cell phones, they can register calls inbound. But what that does is that give you an idea of a phone number. You can run the phone number and find out who it's registered to. So I can see whether or not these people, based on the conversation, are part of the organization. As you move on with that, you also have an obligation, which we were taught as police officers in the State Police Academy, to get B certified and A certified to monitor, is things that aren't relevant. So for an example, and this is a personal, I worked wires. Hello, yeah, he can't go to school today because he got ringworm. Now, is ringworm a trick word for drugs? No, it's that Junior got ringworm and he can't go to school. So I have an obligation, and I used to have a little notebook I'd write, Junior's ringworm. That's something you want to hit the monitor and not record, because it's a personal item. Now, I also had calls where, the stuff's here. We're going to put the dog out and we're going to cut it. Now, you might not know what that means, but what that means is to put it in them dime bags or nickel bags. They would put the dog out of the house, which was a pit bull, and they would then cut the dope in case any police came. You had to deal with the dog, or some nefarious person that might want to steal your dope. The dog was there for protection. Why is that important? That's important for the surveillance people, or if you're going to execute a search warrant on the property. You need to know how they operate. That is, the danger is that the dog might be there, so you better be ready to deal with the dog. And again, as you argue to the court, this is the kind of important information that may not be directly related to the crime, but it's related to the police officers and their protection. So going all through that, there's a termination process where you stop the wire, and usually that's done in conjunction with, if there's a raid, because after the raid, there may be discussions with your attorney, other things. You don't even want to be there for that. So you better have your case worked up and ready. And when the team decides to hit the place, it's usually because there's a delivery. So what we have seen in all of this is legislation that was developed by prosecutors. In Allegheny County, Mike Riley was the pioneer on that. Although, if Mike was here, I'd still say it. He plagiarized it from the New Jersey statute. But we had to make sure that he cut out New Jersey in the narrative. So what that was doing was creating a vehicle for the police to do investigations, initially for narcotics. But this has grown into white collar crime, drugs, guns, all kinds of things, prostitution, sports betting. There's a police officer who I worked with on the team, Louis Gentile. Louis and I were fast partners in the wiretap business. He was a state trooper and I was a county policeman. But the state police used to love to do raids at the Super Bowl. I mean, they would put pen registers up, get everybody ready, and on the day of the Super Bowl, bang, they'd hit the place because there was a lot of money going back and forth on the gambling. And then all of that stuff was then put together. And then you would go to the preliminary hearing. And there was a famous attorney, Jack Dougherty, who had nice cufflinks and was a great defense attorney. And when he would see me show up at the preliminary hearing, the DA never wanted to offer the wiretap at the preliminary hearing, more often than not. But Jack knew if I were there, there was a wire. And I'm sure that that sort of had some effect on his defense as it worked out. And I know it had an effect on his fee because we hit a house, it was a big gambling case, and there was about $35,000 in a secured place. And so I asked the suspect, could he count it and put it in an envelope and sign his initials and date it and the amount? And he was calling me all kinds of names while he was doing that, cursing at me, but he did it. And I put it in the evidence bag and it was distributed. And apparently Jack immediately filed for a return of evidence because I couldn't show the connection. And he thanked me, not as his client cursed me, but that was his fee. So he had his fee upon the return. So it's kind of something you learn as you go. They don't teach you this at law school, but it was kind of funny because Jack said, thank you for you being on the job and your honesty in making him do that. I said, Jack, your guy called me so many names. Anyhow, so we're looking at, the statute overall as it relates to the phone. And those certainly war stories. The successive wiretap cases are both on the side of the prosecution and the side of the defense. And usually the defense is successful in wiretaps because the prosecution abused that power, which gets me back to that hydraulics of justice. You balance that, and if the police did something that was either semi-egregious or egregious, and the court in its infinite wisdom decided that this would be suppressed, it has a huge effect on the outcome of the defendant. In other words, a case might be dropped because it doesn't comport and comply with the elements that the DA has the obligation to prosecute. So remember, the prosecutor represents the Commonwealth, not the cops, and they have an obligation to put the case forward. One other interesting thought that I thought I should bring to not all of your attention, but some people in here that are obsessed with payphones. I noticed in the news last week that the last payphones in Manhattan, and there was a video, were removed. So there are now no more payphones in New York, if payphones are your thing.
I still carry the dime in my pocket.
See, he's got the
My
dime.
first grade teacher, I still have them.
You can't buy anything with a dime. So anyhow, that leads us to the Wiretap Act, and that leads us to, in my opinion, just as the law, if you look at the force of the law, there are things that need to be imbalanced by the law. And I think that's the beauty of the law based on all of those things I told you I've done, and how I view as a judge trying to make that balance every day, being a judge, in my opinion. And John, you can quote me on this. The only thing I have to do is the right thing. And that's why judges should be looking at it from that perspective. And I know there may be disagreements. You can disagree with my decision, but my decision is based on way back when I was young and dumb and I was a Navy Seabee, and they taught us measure twice, cut once. So look at it all, take it under account. The legislator has their job in all of this, and the legislative intent of the Wiretap Act was to create the possibility to create an investigative aid, and in that investigative aid, balance the rights of people. Now, we might see another example of that has nothing to do with phones, but everything to do with weapons. Should you have an automatic weapon? Do you need an automatic weapon? That's a decision for the legislators to make. And I suspect they may be revisiting the legislation in that area, but that's how this all evolves. And the fortunate thing is, as lawyers and judge, because I'm part of that same system, we have a lot to do with that interpretation and how that affects people in this country. And I can tell you, having been overseas, not everybody we might have a bad system, but it's a lot better than what you can find in other places. So I've said too much, but I think it's important to look at that. And here's an example with the cell phones, how a technology emerges and it's collaterally balanced by the law as it relates to your private conversations and how it relates to law enforcement, because that's what really Chapter 57 is about. So with that, I'll stand down and let John tell you more about payphones or whatever he's going to tell you.
It's funny you say that. One of the lawyers in our firm on Monday said to me, he was going through I think he was going to an estate sale just to mess with me. He says, if I find a payphone, you bring that with you and Judge McCarthy. I said, if you find one, that would be interesting. But what the judge gave you here, and you wonder about why the wiretap, why the history of knowing it as a lawyer brings us full circle to the cell phone. And before I forget, did you ever get injured going up a pole to hook the wires?
In the State Police Academy in training, they had the Golden Splinter Award. Fortunately, I didn't win it, but a state trooper from Philadelphia did. And that's called gaffing out. We're in training, we didn't have those little things that you put on the pole. We had gaffs. So you had to lace them up, stick them in a pole and climb it. And if you fell, your initial reaction is to grab the pole. And that's where you get the golden splinter.
I got it. I meant to ask you that. But he did say a famous thing that you should know about Judge McCarthy and his background, and I've known it even before he said it at RMU, is that he learned it from the Seabees, measure twice, cut once. And that's a good way to look at sometimes your practice and breaking a case down, especially now we're inundated with new technology. So that part of his repertoire, although you might find it funny, means a lot. But he also said something very important, that is to bring everything full circle with the wiretap law, and his knowledge of it is, if you get anything out of this program today, is the words reasonable expectation of privacy. That is the key thing, and that was the key element he talked about wiretapping and what the law is evolving into cell phone use. Because a lot of us aren't prosecutors or defense attorneys, we're civil practitioners. And that's knowing the Wiretap Act, knowing some of the basics, and it's in the material. I'm not going to sit and read it. I read it and it bored me. I learned more from him practically than reading it. And that's what you should take from it, because now the younger generation of lawyers and us older ones are still figuring out the use of this little thing. And he talked about reasonable expectation of privacy. Now, I don't know who does family law work or who does any type of civil work, but you see people every day with the phone in front of them, walking on the street, Some have two phones, and that may be the criminal element that have the two phones. One, a throwdown. That was the term. Yes. I have trouble dealing with one of these things. I don't know if anyone else here has it. I think there's two younger lawyers in the back, and they probably know this better than I would. In fact, I have to ask some of the young ones in my family how to install an app and what's this. When I was first getting this, I asked my younger daughter, what's a smartphone? But you don't know that, Daddy? You don't know that? No, you have the flip phone. No, you gotta, and what's an app? I had to learn all these other things. This thing is probably listening to us right now. How many times does someone see something on TV? I'll look something up, I'm watching a show, and I'm typing the first three letters and it comes up. That's a little scary. So now it's come full circle, just like that Pacific Bell guy said in the 50s. Now you could see each other. During COVID, my family lives in Scranton. I was able to see my mother and talk to her. Totally amazing. I didn't know, and I'm going to share you a personal thing. It's nice he talks about his children. Well, first time I had this, came home from court, my daughter's in nursing school. My phone rings and I see her face. Well, I set it down and I do it, and I was taking my tie off and my shirt, and I heard and I'm like, what? She goes, don't take your belt off, Dad. I could see you. Like, oh man, this thing really scared me. That's a true story. If she didn't do the I would have so that is true. So if someone does that, you're caught on this. And that's the name of our program, Caught on Camera on your cell phone. You could video weddings, you could video other things. Now, the key thing the judge said is expectation of privacy. Now, I'll cite you a case that's in your material, but I came about years ago. I had a custody matter, and I had to research a brief for one of the other lawyers. Our client was the mother. They were inside an examination room at the doctor's office. And the husband was always abusive. She wanted to be able to prove it. We didn't even counsel her on it. She turned her cell phone on and was holding the baby. And she's videoing. And he's holding the baby. He's calling her all kinds of names, making gestures towards her, and so forth. So she records this probably about 20 minutes. We get the video. She comes in our office. We look at it. The next day, we get a letter from opposing counsel citing the wiretap law, quoting it, saying your client is in violation of the wiretap and pardon me?
It's a fellow.
Yes, yeah, quoted and put our client on our office on alert. And so I did some of the research because I know everyone uses the cell phone, and it's out. This was about 6, 7, 8 years ago. So I come across a case. Now let me tell you the facts of our case. In an examination room, youngest baby in hands, father grabs the baby and is holding the baby. You can see it on the video. Youngest daughter is sitting down next to mom. So there's 4 people in the room. You can watch, the door's open, and you could see people walking back and forth. Nurse came in, I believe, and she had a chart, walked back out. So with that in mind, I did some research and I cited in your materials, there's a case called Commonwealth versus Large. It's a lower court opinion, so it's persuasive, if anything else, not presidential, but persuasive. The only case I could find. In that case, Mr. Large was charged with a felony violation of the Wiretap Act. A nursing facility reported him to the police, and this was in Lehigh County. That's near my hometown area, Lackawanna County. He went in to the nursing home to meet with the director of nursing about the care of his daughter. He wanted her moved. He was upset with things. They were always on alert about this person because he was energetic, flamboyant, caused scenes. Unbeknownst to them, he had in his eyeglasses cameras. They were designed, now they're called Google glasses, I think, if I'm right. But back then he had and no one noticed it. So he's video, and now he's in a room, the head of nursing, talking to her, doors open. There's another nurse shares a desk near her, like a cubicle. I don't know if it was a cubicle, but remembering the facts of the case, she's there because these are key facts. And you could hear conversations, people walking in and out, handing papers, the director signing stuff, and they're getting worried about her because he's getting flamboyant, boisterous, and whatnot. So they don't know he's taping. This is where he gets himself in a pickle. He takes his glasses, downloads them to like a SIM card. I guess that's the word or whatever. He takes it to the FBI office in Scranton. If I remember where it is, I know right where that office is. So he travels to Scranton, takes it to the FBI. The nursing home finds out about it and takes it to the district attorney and reports him, just like this lawyer in our case was probably going to go to the DA in Allegheny County, cited the Wiretap Act, your client's videotaping. In that case, the judge was, I guess, if I read it right or remember, he was constrained, I think it was word, to dismiss the charges against Mr. Large. And the basis basically was reasonable expectation of privacy. And he went through all the facts. The door was open, shared with another nurse, papers, people coming in and out. So the director of nursing, he found, had no expectation of privacy. Rather, if the door was shut and they were in there alone, probably would have been a different story. Now, fast forward to my case. It was in Westmoreland County. I don't remember the judge, but if it was Judge McCarthy, he said, John, you better measure twice and cut once. So cutting once, I wrote the brief, and the other lawyer went and argued it, and I quoted Large. Well, same scenario. Our client was with her daughter. The husband was looking, and he knew that he was being taped. He could have objected, and that's what part of the argument was. He didn't object. He let it go on for 20 minutes. People were coming in and out. Well, he analyzed our case, the judge up there, in light of Commonwealth versus Large, although it was not presidential, it was persuasive because there was no other case on point. We argued some other Commonwealth cases in addition. Opposing counsel writes her brief and says that doesn't apply. The room is different. The yelling and screaming of her client is inadmissible. So the judge took it under advisement. And what he did was he took the phone and he said, I'm going to mute it. I'm not going to listen to the audio. And when he saw exactly what we depicted in our brief, he allowed the video evidence to come in for the purpose of showing the issues of custody with the daughter, with the child, and how husband treats mother. So the key issue was reasonable expectation of privacy. He lost it. The door was open. I think the judge even said if they were in there alone, even with 4 people and the door was shut, one being a kid, he wouldn't have allowed it. So watch how you advise your clients in videoing stuff. I mean, you can go around society, people are videoing a ball game and doing this. There's no reasonable expectation of privacy. If the judge was still a police officer, he would probably be going investigating if something happened at the stadium, who had cell phones. Can I take a look at them? You see them on crime shows on TV. They're going around looking for cameras that are out in society, but you don't hear the voices. That's one key gray area, and I'll leave that to the judge when he comes back with a little more wiretapping. But the courts are reluctant to listen to what's being said, but rather will look at what's being done under the theory of reasonable expectation of privacy. Was there a reasonable expectation of privacy? Case in point, back in the 80s, not with other payphones, we had answering machines. You leave a message on the machine. Can you bring that into court if you're trying to prove what was said or be demonstrative under the rules of evidence? Can you bring that in? The answer is yes, because the person who left the voice consented to being recorded. That's the other thing about consent. You heard the judge talk about one-party and two-party consent states. There's only 11 two-party consent states, and the Commonwealth of Pennsylvania is one of them. The other 39 are one-party. meaning they don't have to get the other party's consent to be recorded. And I'll get into something later on that with your cell phone and what you're using, whether or not, well, that's the other issue. I might as well get into it now. The reasonable expectation of privacy. If you're a two-party consent state and someone calls me and says, I want to tape this, and I say, no, they have to stop. Otherwise, they are violative of the wiretap law because I made a direct quote, do not tape me, do not record me. So we're one of the last remaining two-party consent states that are out there. But for the ethics part, we'll get into the things you should do first. What we do in our firm is we know clients have these devices and they'll come in and you got to see this, you got to see this. And before I look at it or we talk to them, if they're already retained by us, in our retainer, we do tell them how to kind of use these things. I'll give you a quote from our retainer, but be careful first what you look at. And actually text messages now are used in courts. Evidence are brought in. I've actually used them in estate cases, not some before you, but when you have two beneficiaries litigating against each other, sometimes text messages could get you in trouble. Case in point, I have now, and I don't think you're the judge. It hasn't been assigned to a judge yet, so I'm not speaking ex parte or whatever on the case. I have a client whose husband died, second marriage. His son, who was the outcast of the family, was written out of the will. Specifically, I had the will in front. The kid was basically, lack of a better terms, a loser. He would come to dad when he needed money. He had a drinking issue, drugs and so forth. So much so that dad had to get a PFA against him years ago because he came and beat up dad. I find out he's at the funeral home, and the first thing he walks around in, and he's a laborer, can't hold a job because no one wants to work with him. I can't wait to see what I get in the will. I can't wait to see what I get. So I already now, she comes in and says he's threatening her. My husband is even dead. His dad is even dead and buried or cold, how society speaks. And he's texting her nonstop with foul language, calling her everything else. I'm moving into your house. So I warned his attorney. I said, if he keeps this up, I'm going to go to the district, I'm going to go to the magistrate, and we're going to file at least harassment by communication and so forth, because he's using now the phone as an harassment tool to her. Not talking, but he's using text messages. So that evidence gets demonstrative, and for Cliff Note version's sake, I printed them out and showed them to the other attorney, and he got the kid to wise up a little bit. So not only videoing, but texting can get you or your client in a pickle, lack of a better word. I'll stop right there. We've been going a little bit. We could take a break. It's 20 after 2. How about a 10-minute break? Unless the judge wants to add anything at this point. Or when we come back? 11 minutes. All right, 11-minute break. Any questions at this point? I hope we're not boring you.
Let me finish my cracker.
All right. While the judge is finishing his crackers, we'll pick back up with the little break we had, talking about the two-party consent states. How many times do you get a phone call or you get some number on your phone and you pick it up and blah, 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 this call is being recorded for quality assurances? Who likes those calls? Nobody. No, it depends. So I get a lot of that when I do estate work from creditors. And I've made it a practice where I tell them right there when they call, I'm not consenting to you taping me. Well, what do you mean? You could drive one of the representatives crazy. What do you mean? I says, you're calling on an estate, right? I'm counsel for the estate. If you have a problem or want to talk to me, and it's who you are, write me a letter. And I'm very reluctant to be taped. I had one person who was so astounded on the other end. She said, no one's ever asked me that. And I said, well, what state are you at? And I knew the state she would say was not a two-party, it was a one. And I said, you're a one-party consent state, and you're telling me Pennsylvania's a two-party consent state. Put me on hold, had to talk to her advisor, came back on, we'll send you a letter. Wouldn't you know, 2 weeks later, I got a letter. So be careful of those situations. I don't know if it's based on what I know we're teaching. I believe that's the right thing to do, to watch what you say and disclose. There's that expectation of privacy. And while we had a break, I was talking to one of the participants here, and she mentioned things that we all run into, that you get clients that'll post things not just on their phone or text, they'll post them on various websites, like Facebook is a popular one. Those things can come back to haunt you. What we do in our practice, I told earlier on, we put part of the fee agreement, we have language to the effect, and we make it bold so they see it. Please note your use of social media can be detrimental to your case. Our firm expects you to refrain from discussing your case on any social media, including but not limited to Facebook, Twitter, Tumblr, TikTok, WhatsApp, Instagram, Snapchat, etc. I only know of Facebook on here. I don't even want to get into the others, what they do. And it says, this includes not only refraining from public postings, but private messages as well. Comments on social media can be and are often used in court proceedings. In addition, the removal of social media information or the invasion into your spouse's computer, even if the computer is marital, without permission by that spouse, may be used against you by the court. If you don't have fee agreements with some type of this language, I recommend you put something like that in your fee agreements to put your client on notice what can happen using this little device in our hand. Now people have them on their phone. I'll get in an elevator and it's quiet and someone's talking and I think they're talking to me and they're talking on their phone. There's a little earpiece in there. I feel, you feel, are they talking to me or what? This little thing could set off a variety of things. So for ethics purposes, you have a duty to your client to disclose under the rules of professional conduct what you expect from them and what they should know about using this device. And I don't know if some had, but I've had the experience where we tell them that and they still don't listen. And something comes back or they'll say, it's my sister posted it. I didn't do it. I said, well, someone, you need to not discuss this case because I'm getting correspondence from opposing counsel that things are being posted. Or I see them on a motion. I'm sure the judge did it when he was in family division, posts of text messages or Facebooks and stuff like that. Those things, there's no expectation of privacy because you've let it out to the world. So you lose that umbrella. So that can be used against your client in court if they do it, or you use it to your advantage if someone's doing it to your client. So, but be careful advising clients, make it a point, especially when they come in, and videos aren't just in family law cases. I've told you they're in estate cases. There's videos of them taking personal property out of the home or messages back and forth between heirs and language that's inappropriate. It's all usable tools for your case. So be careful. Your knowledge of the Wiretap Act is also important to tell your clients that you can be subject to certain things if you're videoing somebody or taping someone without their permission and it comes of light. I mean, you could sit your phone down here and I could have been taping all of you while we're going on, but we're in a room where there's no reasonable expectation of privacy. We're in a sole setting, as the judge said, reasonable expectation. Then you got to be careful. And then you should tell the other person, I'm going to tape this. Do you mind? And if they consent, I would make sure the consent's on here. I don't think anyone's going to consent to be taped. But I mean, these things are everywhere. Ballparks, you're going out to restaurants, things are being videoed. And at custody exchanges, we talked about at break to someone, this is like the hottest item in a custody exchange. And typically the exchanges are in a public place, most of the times in a police parking lot. So or Chuck E. Cheese. That's pretty good. Or Chuck E. Cheese, or even at a school. So be careful and tell your clients how this could be a bad tool. This is a weapon as far as I'm concerned. It's a weapon. if it's used right, it's a good tool if you do it for the right reasons. You also get people with children that are subject to, you'll get the client doesn't want photos of the child being taken. Well, the father is also part of the family. Unless you get a court order and deal with it in judicial conciliation, father can send a picture of the child to his brother. And these are pictures of my child. You'll get people that are very touchy about their children's pictures being on there. And that's a gray area too, being that there's predators out there. There's scammers. Got to be careful what you do and say on here. This is a loaded device, as I said. I'll get back to finally some quotes later on from certain articles. But here's another thing to be mindful, not just the phone, but GPS stuff. Spouses are keen to tracking the other spouse. And they are permitted to put a GPS on a vehicle if the title of the car is in their name or it's joint. If the other spouse owns the car and it's in their name and you put it on it, you're probably going to get your client a slap on the wrist, because GPS and tracking on the apps would be violative of that. That car is owned by that one person. So there's an expectation. It's my car. It's private. So be careful. Yes.
So there are tracking features on your phone, just that your phone can be tracked. Does the phone, if the spouse wanted to track location of the other person's device, I mean, all you need is their Apple identification number, like whatever their login information. Does it matter whose name the phone is in? A lot of people are like family plan.
I'd defer that to the judge. If that became in front of you, how would you rule?
A couple of things to remember is that the app is controlled by the phone. Now, you and I are married, because my wife has a phone number and I have a phone. Does that mean she's controlled her phone? And then I can't, even though it's a family plan, do I have the right to track her for whatever purposes? Does she have the right to track me because it's a different number? And so that goes back to the expectation of privacy question that you have to analyze, because as John said, title is important, but when you break that title down, the plan I have is a family plan. And not only, interestingly enough, from a former wiretapper, my family plan includes my two daughters. And there's a reason for that. Because if one of my daughters, one who lives in Columbus, Ohio, and one who lives in Los Angeles, if something happens to them, the police are going to need a warrant to look at her phone. But because it's a family plan and we're in agreement, I can tell the police, you have access to the phone. So the carrier can deliver that information and they can find the last time. And in a lot of cases, by pinging, you can find where the last call was made from that will give you within a rotation of how far away they were. Now that sounds ridiculous until I tried to explain it to my wife and she thought that's a great idea. I'm not apting them and looking wherever they're going. But if they go off the radar screen, I can see their last contact. And then we can also see who they called and who they got calls from, which is important because it may relate to someone as a suspect or aid in the investigation as to find out what happened. Now, that was all explained to them. They understood that. What's more important is I pay for the phone.
Right.
To them. But to me, it's important because I do pay for the phone and we do have authority over that. So title is important. And as John said, you can go buy a car, your spouse is not with you, they do the title transfer and it may not be in my wife's name or vice versa. So now you have a title that's in the name. And so do you have dominion and control and an expectation over that car? Now, if you get divorced in family court, that becomes an issue. The issue is not difficult to resolve because at the time you were married but think about what you're doing. You're proving that vehicle, even though it's in a different title, and in orphans court, it could be the title of a property that was bought and then subsequent married or bought and then settled in a divorce in his or her name, and now you're remarried. Is that property, does the first spouse have an interest in that property? Not a legal interest because there's no title interest. And there was evidence of the transfer, which means, as we go back to the law in general, intent. First question, what is the intent? And then you go from there. So if it's a government agency, police agency, and I want to track you, I need a warrant. But if it's within a family, that's a little bit different because there could be some consent there. But if I give no consent, and as John said earlier in his demonstrative explanation, the judge cut the audio and just went to the film. The judge didn't want to hear that and relied on expectation of privacy as to what you said. But the judge was becoming a witness, seeing what had happened. Kind of like my football coach used to say, there was no audio, but I missed the block. And he would run the film and say, McCarthy, you missed the block. Then he'd run it again. And then he'd run it again. At some point, I thought I might have some expectation of everybody in the room not seeing me doing the bad thing. But the coach was trying to make a point that I missed the block. So I had to deal with that because I had no expectation. I was playing a game that was being filmed. So it's the whole point of, again, I harken back to each case, it's its own unique facts, no matter how trivial or how important. And as you break it down with the same methodology, you can actually get to a position that you are comfortable with and that you can make the argument on. As the case John pointed out, again, I'm in a PA of a doctor's office, and there are people coming in and out, and they're talking. Well, they're talking about my case maybe too, or some other patient's case. Now you can jump up and say HIPAA, but it's not HIPAA. When the doctor closes the door and wants to talk to you, then that's HIPAA. That's important. And when HR calls to the doc and says, tell me about McCarthy, that's HIPAA. He can't just say it because you have an expectation of privacy. So again, you use the same analysis on any kind of interaction you have. If you go into a grocery store, you have an expectation of privacy because they have security cameras and they keep that film for whatever period of time. And that film is used against you in a court of law, or it's used to establish that you were there at a date and time, which may be important in another way. I had a case where I subpoenaed, my client was accused of assaulting a person, and in the course of that, the argument that the defense that I was making was, this wasn't an aggravated assault, this was consent. They're rolling around in the front seat of the car, sucking face, okay? She comes home late, the boyfriend's mad, blah, 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 blah. She's calling him back and forth. I subpoenaed the phone records. The records show that she was having these ongoing conversations, but never told her boyfriend that she was with my client and that they had met and they were having a discussion in the front seat of the car. Wasn't wholly bad. She wasn't home. He's mad that she's not home. So I got her phone records and his phone records. He's calling her every 5 minutes. leaving messages. Where are you? Where are you? And she starts calling him back. And there's almost a whole day before she decides to say, I was at a bar, I met this guy, blah, blah, blah. And the question was, well, why didn't you call the police? I mean, if this was an assault, this was a consensual relationship, and she was trying to hide it from her boyfriend. And so when I got the phone records, the DA started laughing and said, you're using these records against me. Well, you were a DA, you had all these phone records. I said, well, John, that's, this supports my guy's contention that he had no idea that, it wasn't like there was no consent and he had no idea. But these phone records actually produced showing she had no problem until she told the boyfriend where she was, and she said it was an assault. And so he insisted on a criminal case being filed. Well, my guy got charged. And when the MDJ heard this and saw my evidence, dismissed the case, and the DA didn't refile it. Question.
So one of the things that a judge would look at, or somebody else would look at when you're doing an analysis, would be even whether a person had, say, a pin on their phone,
Mhm.
whether or not somebody could just go and just pick up the phone and see everything that's on it, or whether or not they had a pin that kept it private.
Right. So if it's your phone and your phone number, and you don't want anyone to know that, do you have a reasonable expectation of privacy? So, like in my house, I have no reasonable expectation because my wife can look at the pin, and if I said no, I would never get to trial. I'd be sentenced first and then trialed later. But like, why are you trying to hide? But that's the question, Mark, as you analyze it, how the question will answer itself when you break it down into those elements. And, like I say, measure twice, cut once. When you start putting that, if you only use one measurement, you might be short. You only have so much lumber. So don't screw it up, measure it twice. That's the same way in an analysis of all of this. Cameras are another thing that, from the police standpoint, now every department's going to camera. Now, here's an interesting question. When do you turn it on? Because not all cameras run all the time. When does the officer decide to turn it on? And should it be determined that the officer didn't turn it on in a timely manner to start the sequence of whatever you see? But again, that camera, you may have some expectation of privacy, but if the police officer's in the course of investigating or seeing even a misdemeanor committed in their presence, that camera records it. Now, that camera, as in a lot of cameras, is a sword with two edges. It can protect the officer, or it can bury the officer. But it's there to balance. Like, it's not what he said, she said. It's, here's the film. And I think you'll see as cameras become more readily apparent how important they are. The Floyd case, it wasn't because the cops had cameras on. It was the pedestrians that had cameras and were filming the arrest of George Floyd. The question is, did the officers have expectation of privacy? No. I can tell you from what I saw, Mr. Floyd wasn't very cooperative in getting into the car. And they had to figure out a way to handle him. There comes a point, though, when that officer went above and beyond controlling the suspect and, in fact, killed him, and was subsequently convicted by a camera. And that camera was by civilians who were, if you see the film, they're lined up on the corner. And the other officers were culpable. Well, he's the officer in charge and we got to listen to him and we're rookies. No, you don't. run the risk, stop this idiot for what he's doing. I mean, that's the question that they were charged with, a negligence in essence, that they didn't do or step forward. But that case is a prime example of the officers had no expectation of privacy because they're public servants and they're in the course, in the open. Every one of those people, just think about this. Take all of those cameras away, put them in a court of law to testify. Who's the jury going to believe? They're going to give the cop the benefit of the doubt. Okay? But here, it's a camera that took that film on this little thing that made a difference in that case. I don't think that officer gets convicted if it wasn't for the film. Because jurors may be convinced to give the benefit of the doubt to the police officers. Is that right? I'm not sure it's right. I'm not sure it's wrong. I'm sure it's what it is. So, okay, you're a cop and you're dealing with this guy. The camera also tells me he was difficult. They were trying to put him in the vehicle. He didn't like that. And I don't know if you remember, he's a big dude. If he gets control of you, then you need the cavalry. The cavalry shows up, but the cavalry has two purposes, in my opinion, those officers. One, to assist. Once he's on the ground and under control, wait for the wagon. You don't have to do what he did. You don't have to do what the deceased last words were. You did above and beyond. So there comes that point where he wasn't measuring twice. He was imposing something that went beyond the scope of his authority. And thank God, those people who they were trying to shoo away had cell phones. So as Edward R. Murrow said with TV, this is either the greatest thing in the world or the damnedest thing that ever happened. And so in the beginning, back when I was young and dumb, and the TV was black and white, you watched TV and there wasn't as much editorializing. Here's the facts. As it evolves, it becomes more, well, we got to sell cereal. And the cereal people want more of this and that and the other thing. So Fred Friendly and Edward R. Murrow and all those people that were there in the beginning saw it as a tool. And then it evolved to what it is today. Of course, this is not the opinion of the court, it's my own. And then Ted Turner comes along, creates a whole new channel. And now everybody's trying to fill the air with their own little channels. So they say the same thing 600 times. Think about that. It used to be 3-4 channels and it is what it is. And now we got to fill the space. So if you watch the war in Ukraine, I see the same footage. And the problem is there's a war going on there. Okay, I get that. But you have to fill that space. And so the pressure to fill it isn't balanced by what it is to give me just the information. And the pressure in the George Floyd case is what happened? I want to know what happened. So if my spouse is abusing my child and we're having a fight and I pull this out and take it, can I play it in front of the judge in family court? Look what he or she is doing to the child. If I'm late at Chuck E. Cheese for the handoff, is that a major crime? Well, there are people that will open their camera and say, okay, look, at 6:30, I'm here in front of Chuck E. Cheese. Where is he? And then some judge has to deal with that because the parents are fighting each other and not looking at the child. And yeah, it's a technical violation, but for God's sake, yeah.
Okay, in the same Husky situation, mom gives the child a cell phone or one of the little tracker watches. Now, she says it's for the child's safety and all that, but dad saying she's using that to keep track of my time and what I take for child. Doesn't that have reasonable expectation of privacy that you don't need to know that I took her to the Southwest Village and then we went to Chuck E. Cheese and we went to Kennywood. That's invading his privacy because she's using it for the safety of the child for when she needs to get hold of the child.
Which is an interesting scenario because the adult is making a decision and whether the father has an expectation of privacy in that. The child's then put in the middle. You're imposing your non-consent on the child, and the child perhaps is being given pressure from the adult to film all of this stuff. And as you might know, in cases of divorce, one parent's telling the other parent to do this, here's the kid in the middle, but my kids didn't have cell phones. They had hardwired phones. So when my daughter Mara got on the phone and said, let me ask my dad, that meant no. Because she could say, he said no. When cell phones came in, or when she decided to conspire outside of the phone, I didn't know she was going to this party at Tiffany's. And when she had a cell phone, I didn't even know this conversation was going on. So it's interesting, again, how the technology has evolved and how a child does have an expectation of some privacy. Is the child's age important in this? I think it might be. Are you 18? Are you 17? Or are you 14? Or are you 5? Because there's kids that are 6 with cell phones. What is the kid filming? It's an event. I like it. I want to show, we're having fun at Kennywood. Or are you missioned to do that? And then does the mother take the phone off, go to court, file a petition to get custody of the child because the father's taking, doing whatever, or won't let her. There are also parents who say, you're not allowed to use the cell phone when you're on my visitation. And that's something I think that has to be negotiated amongst the adults.
It's been on video, they use them to say, okay, I'm tracking where you're taking this child. So I go to court and say, you're an evil parent because you stopped at Joe's car while you had a kid for 10 minutes and bought a burger, even if it was innocent. But
Right.
You're stopped, they're keeping track of everything dad's doing with the child.
Or I went in the bar and I left the kid in the car with the windows down.
Yeah.
Yeah. Oh, okay, that makes sense to me.
Yeah.
I mean, but it's interesting how that weaves its way into expectation. And how do you balance protection of the child with the risk of being with a parent that you believe isn't a responsible person? Because you've already made some arguments about the parent being non-responsible. And this is your way of protecting the child. Here's another interesting case. In Penn Hills, this coming school year, each one of the children will be locking their cell phones in a bag when they get to class. The reason is the students won't have cell phones. The theory is they'll have better control within the school of the child, and sometimes the cell phones being this distraction. The question is, the parents raised the first question. What if something's wrong and my child wants to call me? Or what if I want to call my child? Well, back in the day, you would go to the school or you would call the office and say, I have to see my child. Something catastrophe happened in our family and I want to pick the child up. So you would go to the school. Now you can text the child or talk to the child, or the child can do this all day. The theory behind locking these down too is the violence within the school and this banter is eliminated when the phone's locked in the bag. And it'll be an interesting experiment, one, to determine whether the child has an expectation of privacy and can the school district do this if someone raises that issue? And number two, what effect does it have on the school? Like, does it calm things down? Or do we see more videos of 17-year-olds beating up 16-year-olds and hall monitors, teachers trying to break this up? I mean, I don't know that that's caused by cell phones, but I know another thing. Those cell phones are showing us those videos of that assault within the school. So it's really, this thing has two edges to it. It can cut and it can heal. And again, does less than 18 years old have expectation of privacy? Because I go to school here, it's a public school. I want my cell phone. You can't take it from me. It's going to be, it's the school's policy at Penn Hills. So that'll be interesting, A, whether that's litigated, B, what the outcome of the litigation is, and C, if it goes through, which it apparently has by policy, is that going to have any effect on violence within the school? So again, here we are back to that hydraulic, that scale of balancing. It all has to do with phones. Something that started out with teletypes, and then evolved into this, and then evolved into that. And now we're faced with this in today's world. I think it's going to be even more interesting as this evolves into a wrist phone. You can tell my temperature, you can tell my heart rate, you can find out where I'm at. And I hate to sound old, ugly, and a vet, but I remember reading 1984. And because I read a lot of science fiction, Isaac Asimov and all those people, but think about it, all of that monitoring. Now, when I put that watch on, do I consent? There's an interesting question. Before we even get off the bus, I put this watch on. Do I consent? There's probably someone in this room that has a watch like this. See?
Fitbits, yeah.
See? And I only wanted cheese and crackers, and I know that couldn't get here any quicker. But if I had a wrist phone, maybe I could have called and said, "Where are the cheese and crackers?" And I apologize to those who are on video. You didn't get cheese and crackers, but I owe you cheese and crackers. It's funny. It's serious as a heart attack. And it permeates the law in certain ways from an evidentiary standpoint, that even though we had expectations of how great this could be, we had no expectation as to how effective or the effect it would have on the law. I rest my case. Yes, ma'am.
Couple questions. One is.
Could you identify yourself for the record?
Sure. Do I have to?
No.
Okay.
You have an expectation of privacy.
It's Lori. I'll say it anyway. I do have a Wise camera at home, one of those little cameras to tape any doings outside the door. And I'm sure a lot of people like their Ring doorbells and all that stuff. And mainly got it because there were kids in the neighborhood throwing stuff at brand new windows that my landlord did put in. So is there a reasonable expectation of people that are out in the streets? I mean, I do have a sign that says "Smile, you're on camera." But
Well, that's an interesting question, which then gets us to another level
okay.
of surveillance as well. But some of that surveillance can go to your phone. And
True, I can even look at it
right.
on my phone.
So let's think of another effect in our society. Amazon. I get all these packages delivered to my door. You have those cameras there, and I come down the street and I have an expectation of privacy until I make that left and walk up your walk and go on your porch and remove your personal. That camera then assists the prosecution with law enforcement of, I think they're called porch pirates. Somebody's stealing it, but no, you have a police department, you can call dispatch, and by the time they get there, the porch pirates already got your gear. But you have evidence that you have secured. The argument is they had, what are they gonna argue as defense? I had an expectation of privacy when I was stealing your personal. Yeah, that doesn't float a lot in the bench. But someone might think, oh, okay, this is terrible. We shouldn't take your picture while you're stealing other people's property. And I'm not even going to the trespass, because once you trespass, I think that expectation of walking down the street evaporates. So it's not a violation of the Wiretap Act. You don't even have to put smile you're on camera there, because you don't have to tell them they're on camera, because what they did was cross the line. And once they waived their expectation by coming on your property uninvited, then that film is used as Exhibit A in the case against them. Even more interesting is usually porch pirates travel in at least 2s and 3s. So number 2 porch pilot sitting in his car, and your camera captures their license plate. Now, doesn't that help law enforcement? Because now they have an accomplice in this case, and it's an inchoate crime because he had reason to believe that his pirate mate was going up there not to see you, but to take the item. And then I can run the plate, because driving is a privilege and not a right. And I have that license plate number, and it's registered to Mike McCarthy. So I show up at my house and say, hey, where were you on the night of the 25th? I'm not saying a thing. You don't have to. As my football coach said, the film don't lie. Here's the Buick, and here are the license numbers. Were you operating this motor vehicle? If you don't want to say a word, then I produce that in court. And the preponderance of that evidence clearly states that you had dominion and control of that vehicle. You were there. Not only did your friend porch pirate, but he brought it into your car. What did you say to him when he brought it in the car? Hey, I didn't see a thing. I was looking forward. I don't think so. And then, you say it'll go easier on you later if you tell me now, and then he dimes out his porch pirate buddy, and you get the conviction.
I have one other.
You got a lot of questions.
Just one,
Okay.
just one. And one of our issues here at the library is we really don't have a way of, for security issues. And occasionally we do have belligerent, thankfully not many, but we don't have, within this room, we do not have a panic button. We can call the police, like you said, by the time they get here, everything's done. Are we allowed to use our phones to tape what's happening, even if it isn't? I mean, I understand they're having some expectation of privacy when they're coming up to ask a legal research question. So I don't want to invade that privacy, but if their actions are.
So if I come in here and I
Yes.
want a Mark Twain book, and you tell me we don't have Mark Twain books, and I start railing against you, the first thing I believe you should do is ask the patron to leave.
We've tried that.
I understand.
Okay.
If you ask twice, if you ask nice,
Mhm.
and in the interim, you could probably have another coworker call the police while you're having this discussion. And if it rises to a level that you think is going up the ladder, understand that at some point, words can become actions and actions could become harmful. So if you're behind the counter and you say, I've asked you to leave 6 times and you want to hold the phone up, I would say, I've asked you to leave 6 times. Now, please quit bothering the other patrons and leave the property. And you've got that. At that point, I would go back, I would have a plan where you would secure a room, everybody knows where that room is,
Okay.
and wait for the PD to show and remove the guy. And if he destroys property or she, then they destroyed property, but it's better than having you wrestle with someone that may harm you in a world where a lot of people carry weapons. And sometimes, even though there's security at the front gate, some people can sneak things through. So I would have a reasonable discussion before I would film it, but I would also make what I'd like to call a self-serving statement. I've asked you several times to leave. Do you understand? Please leave the building.
Okay.
There's the elevators, please leave the building. And then I would fall back to a safe location,
Okay.
awaiting the arrival of the police. And then they'll let them handle the situation. And if that case went to court and it was a DC disturbing the peace, the judge would want to hear from the police officers, and they would also want to hear from you as a witness. So he had no expectation of being able to accelerate this. Then he would have gone beyond what is reasonable, and it might rise to the level of disorderly conduct. Misdemeanor 1, misdemeanor 2, or let's say violence. Take the books and start throwing them, which could happen, or assault one of the employees. And you don't deserve that. The books don't deserve that. And the person might have some mental problems that I suspect this is a place where a lot of people come to do research for, that Martian stuff that comes down.
Has to be legal research.
Well,
So.
you could
I
sue
understand.
Mars, but, and I'm not, this isn't legal advice, this is practical advice as to what would happen. And that's something that you, as this institution, might sit down and have someone say, we have a protocol, and if this happens, do this, if this happens, do that. And then have other eyes, 4 to 6 eyes, look at it. And once that protocol is established, that's what you can do.
Thank you
Now,
so
do you have any other questions? All right, 2's the limit. I'm sorry. Anybody else with any questions? Is that more than you wanted to know, right? Okay.
Well, the other thing on that is your taping of what you're doing meets the requirement of demonstrative evidence. So if you go down that one case that breaks down,
Right.
whether or not this meets those 3 requirements, the phone obviously does. And as the judge says, the phone has evolved. It's evolved into a camera. He could check his heart rate and other things. It's an amazing tool that's out there that can be used. But you and one of our attendants was talking about a child using the phone during the custody of another parent. I have a case right now. Well, I'm going to bring it back because I want a ruling. Similar to what you're saying, mother wants to control. She's a control freak. And I represent dad. The child, unbeknownst to dad, she bought another phone for the kid in her name. The child is 10, I believe. And she's getting, what's the term, Judge, we use? I'm having a brain lapse when,
So call 911.
no, when the child hasn't been around the other party for a while.
Not around the other party.
Yeah, they, anyway,
Strange.
no, they were estranged, but you're getting the dad back. It's the words in my head and I can't think of it. Reunification, yes, thank you. So as part of the reunification, we worked out a Band-Aid order, a temporary order where the daughter and son would go live with dad and spend an overnight. So we kind of, it was a stepped up. So son likes dad, he's fine. The daughter is about 10. Her and mother are like this. They're more like sisters. She has her phone, and when they go to bed, he's heard her in the room up to wee hours of the night, even at midnight or 1, talking to her mother. Next time we go in front of the court, we have to put in reasonable time for the use of the phone. This kid eventually wanted to express her desire not to live with dad. So she was using the phone and telling mom what was going on during the day and took pictures where they were at. This is dad's time. He never invaded her time. The point is, and it was good that you brought that up to a judge. If I bring it in front of you and I'm telling you the kid's on the phone 1 or 2 or 3 times, and I get the phone records, 1 o'clock, 2 or 3 in the morning, the kid's 10 years old, and nonstop, I'm sure you're going to probably want to say reasonable time for a 10-year-old is probably 8 o'clock. Cut the phone off. You could issue, and there's a case I think we cite that the courts could dictate use of do not tape after a certain time. I would think, would that be something you would do if you found out the
It
kids
could be
do?
memorialized, it could be an order, and it would have to be followed. And if the evidence showed
Mhm.
that it wasn't followed, you're in contempt.
Yeah.
Go back
So-
to the judge and say, what do you think, this was a joke?
I mean, reasonable time for a child of that age is probably 8 o'clock at night, no more phone calls.
Now,
And-
for a 72-year-old guy like me, I don't even get to the 10 o'clock news.
Yeah, I'm catching up with you. So I have just a few more things I want to add. I didn't get into social media postings, and I'm coming over here because I'm going to cite you a case that you might want to look at, because in our next presentation, we're going to talk about it. This was a case of first impression back in 2018. It's the case of Commonwealth versus Mangle. I don't know if I have the site for it, but I believe the court was asked, it was dealing with social media, Facebook account, and social postings. The Superior Court addressed the issue of first impression, what standard to use when ascertaining if social media has been properly authenticated. And I believe they went to the same criteria. You'll have to read the case. I didn't really get into it. I don't have the site. It's a 2018 PA Superior Court case, Mangle, Magel. Couple things. If Jay was here, Jay's into the nanny cam stuff. And part of your material, Jonathan Volker, because he had a case with nanny cam and he described this really well in his custody case. But anyway, we cite the Mason case, and that's in your first paragraph of the material. And this is where the first time that the Supreme Court, this was in 2021, the PA Supreme Court says, interestingly, the use of recording devices in homes is now a means for parents to monitor people hired to care for their children, have become so commonplace in our society that we now have a name for them, nanny cams. And that is to say, the court says the expectation of a child worker that's going to be recorded is so ubiquitous in our society that we have a name for it. So basically, a nanny coming in should be put on notice that the house has these cameras inside. And I encourage you to read that case. I wish Jonathan was here. He did a real bang up job on the nanny cams. That's the other use. And now you can see the nanny cams. I think you have an app on your phone. You can see, am I right? I'm getting a nod in the back that you were saying about monitoring another parent and doing other things. That's a gray area. And I think the judge explained that right on the phone, if you have a plan.
So you can even do it with pets. A lot of people have pet cameras. so they
Really?
use their pets to do
Yes.
it.
Wow.
Yes.
They're not out there. So it's entirely possible that you should also have to, if you hire a dog walker
Walker.
that has access to your home, that they're being surveilled while they're inside.
And a babysitter, not just a dog watcher, but if you have a babysitter.
Correct. This stuff is really taken off and evolved as we talked about. One other case I'm going to point you to, and the Honorable McCarthy might know this. Justice Todd in our Supreme Court in a 4-3 ruling, Commonwealth versus Davis. And I have the site for it. It is 220 Atlantic 3rd, 534. They found that the Fifth Amendment's protection against self-incrimination extends to prohibiting law enforcement personnel from forcing a defendant or suspect to give up passwords for an electronic device. So if they got the device, he could plead the Fifth against self-incrimination, and the court says that they're not permitted to invade the phone on digital stuff. Am I?
Well, that's correct.
But
what you have to be careful of is your client, the defendant, has to refuse to talk to the police. So there has to be a refusal. I'm not saying anything, and I'm not providing you with permission to search my car, my phone, my pockets. The only thing that they can search is search for protection. See if you have weapons.
Gotcha.
Or drugs, because if you're being transported, they don't want you to jail with drugs. So this is another interesting aspect. And what I foresee in the not too distant future is, and John's right, as to the finger, but we now have a thing called face recognition. So if I'm a police officer and I'm arresting you and I pick up your phone and hold it up to your face, I may be able to see your phone may be open. I believe you still have that expectation. If you deny the police, say, listen, I don't want to talk to anybody, I want my lawyer, I'm not saying anything. Is that saying something? Or do you have a reasonable expectation of the privacy, the contents of that phone? And what's the difference between facial and finger? You can't make me use my finger. How can holding it up when the police take possession, dominion, and control of your device?
That might be a case of first impression soon too. That'll be discussed.
Right.
Um,
And that's a pop quiz in law school.
mm,
I think if you start thinking about it, like
true.
a stop and frisk,
Mhm.
did you have probable cause? And once you did, if you have a facial, you might find information on that phone that leads to an arrest or some crime being committed. Does that give you the right to continue on with your investigation, even though the possessor of the phone said no?
I'm not sure if that's addressed in that opinion, but that would be interesting. That's a good argument on
Comment
that.
like Christmas.
Yeah. Another thing you should be aware of, those that do estate work and stuff, and I know there's 2 estate attorneys here and one up here on the bench, is I think it went into effect a few years ago that the power of attorney statute changed or added that you have to include a provision in powers of attorney for digital assets so the agent has permission, and I think it's required now, that they could access for the party who is the principal in the power of attorney needs the agent to access accounts. So you have to spell that out. And I think the statute has it. Digital assets have become a unique thing too. I'm bad at keeping all these passwords and numbers in my head that I have a little black handbook. It's not the black book address, it's my password thing. And without it, I'd be lost. So I don't know if any of you have people store their stuff on the phone, that could be a problem. If your material is even on your phone for that purposes. But I had the experience a few years ago when my second wife passed and I had to access her phone to get stuff and I didn't know any of her passwords. And the companies, when I was the executor of it, weren't going to give me the info. So I had a tough time trying to find it. If you do estate work, you might want to people who you appoint to know where your material is so they could access your stuff for the purposes of going in front of an orphans court judge. I found these assets. I was able to get them. He probably asked you, how'd you get them? Well, it was a digital asset. I didn't abuse it. I marshaled them in. I brought them in. I think when you die, you lose that reasonable expectation of privacy, right? And you would
Well,
need that information.
I think if you brought that to me in motions, I would make those inquiries. And then I believe that an order would have to be issued to the carrier to gain access to all of this digital data. And I personally don't see it any different than if you have a 401k and how do I get access to that? If you're the executor and you need access to marshal the assets for the estate, I think that's not unreasonable. It goes beyond the reasonable expectation. Unless you produce a will that says, I don't want my digital information, then I would hear you speak from the grave to me, telling me, no, you can't have it. You got to figure out another way to crack this case.
Yeah.
But if you brought that to me, I would guess it would be in the form of a motion, and it would have a reason. Like, I got it, I can't get it, I need it to marshal the assets, to do what I'm missioned to do as executive. And I would sign that, you would serve it on the carrier, and the carrier then would be obligated to allow you in. Because the person that died, I can't serve the order on. And if they didn't leave a list in someone's possession and say, in the event that I die, and show up and show the executive this, we have to get it to marshal the assets. And here's the trick. Orphans court's fiduciary. A lot of people forget that part of what we do in orphans court. And so we have an obligation to assist in marshaling these assets so they can be distributed. Problem solved.
That's a good point. You get a court order, the subpoena should, or whatever, a court order would help you get around the digital asset where you can't find it. Because I've had executors trying to get into stuff and said they're asking me for a PIN and I can't get it. I said, well, we got the short certificates. Well, they're asking me for this. That's probably when you go to a judge and say, Judge, it's being outrageous. They're asking for this, but we know that asset exists. Can you order them to disclose it? And I think they'd have to honor his order. But that's getting
Or
into.
even if you have reasonable belief that the asset exists, because some assets can be dissipated and gone, and you still have the problem of checking, because you as the executor have an obligation to make sure that you had reason to believe there was an asset, you checked it, so you can represent to the court and in the audit, I checked this and it didn't exist. Because what happens is 10 years later, when the state treasurer lists that name and one of the beneficiaries call and say, you're an incompetent lawyer, why didn't you find this? That could happen, and it does. And I've seen that happen in practice before I preached. But, because you didn't know this asset existed. And sometimes in the relationship between people, some people don't share all of the assets with the other party. And so that's where you miss. You can call PNC, you can call, but then you find out that there was, well, you worked at Bell Atlantic and you had a retirement account. When you left, you didn't close it out, it still existed. And, 10 years after, do you reopen the estate? Do you file an amended report saying we just found this asset?
Well, I think the judge said it right. As a fiduciary, you have a duty to marshal them in. And some of the older clients you have, they're not so good with the use of the cell phone or computers. They have to learn this is evolving. This is taking off. For you younger lawyers down the road, there'll be something else. I grew up watching Star Trek back in the 70s and they flip beam me up. Maybe they will beam us up pretty soon. This stuff has come to fruition. It's coming into existence and it's just going to keep moving. I mean, we talk about this now, the judge and I, and tomorrow there may be something else new on this because technology is taking off. Fortunately, the younger society, in the scenario I said about my wife, my daughter or stepdaughter, took the phone and I was the owner of the phone and they wouldn't even, AT&T wouldn't even give me the password. So she was trying all kinds of things. Back then it was 4 numbers. Now you have 6. But you have 20 in the near future. But anyway, she finally was able to do it. It took her 4 hours. Taking, you'd use address, birth date, all this stuff. But I had to gain access to it. And I didn't know certain things. Like the judge said, it might end up on unclaimed property. So, but unless we have any more questions you want to add anymore, I think we're near done. We're 20 minutes ahead of schedule. Unless there's questions, one more?
I have a question. I'm the first part of the store Amazon package, and she got me on a little ring cam. Now, when I walk down the sidewalk and trip in her crack and get hurt, I think, did her ring cam video this to her?
Oh,
Yes,
he's,
yes.
Yeah.
Yes.
yes.
Because under the best
If
evidence,
it's wrong.
it is the best evidence. There's no dispute you fell. The dispute is whether there was negligence on your part, where you contributed, or on a 1-inch piece of concrete that is raised in the walkway.
That was,
So if this case goes to civil court, that's very important evidence. Do you have an expectation of privacy? Well, did you give it up when you walked on a person's property? To some extent you did, but even if you were just there because the mailman put her mail in your box, your mission was to just drop it off for her, but you fell. And if you recall from looking at case law, that inch of the curve of the walkway becomes a point where you knew or should have known that was dangerous. And the film, again, hate to say it, my coach said it, don't lie.
Yeah.
You tripped, and you tripped because of negligence, or you tripped because you weren't paying attention to what you were doing. And to tie all this back together, you could have dropped that mail off, misdelivered mail off, came back, and if that film shows you on your cell phone, are you liable for you not paying attention to where you're going? So a defense could be contributory. You're doing this, and here's what I would do if it were me and I were defending. I'd subpoena your phone records because I could show at the date and time you were on a cell phone. Not only that, the porch cam confirms you were walking not even on a 1-inch piece of trip. You're coming to the last step and you misstep it. That's your fault. We're not liable. We have a porch, we have the steps, they're secure, they didn't fall apart. And even if they did, we didn't have notice that the steps were in bad shape. So my investigator tells me the steps were in good shape. The film tells me you were on your cell phone when you fell, right? Think about how all of that from an evidence, all of this ties into the law. This is civil law. This is negligence. This is contributory negligence. This is defense. This is plaintiff. This is criminal. This is defended. And all from some guy that ran a wire to where, Baltimore?
yeah, Washington, that's where it all started, 50 miles.
And unfortunately, we don't have payphones anymore, so we don't have any scenarios that involve payphones, which probably depresses John because he likes payphones.
I did. I liked it. I shut in the booth.
Because the last phones are out of Manhattan, so there are no payphones in there. But yeah, that's a good case example of what could happen. And then, because we're the moderators, we get to change the facts. That's why I added this.
He did that to the class at RMU, so you can never predict what he's going to do, which makes it lively. I'm going to end on this note. It's not in your material, but it was from an editorial I found interesting at the Pittsburgh Post-Gazette, February 26th of 20, which is 2 years old, so bear with me. There's a couple quotes. Our cell phones are becoming addictive. Does everyone agree here? Obviously, you can't live without them. I always say if you don't have it on, you're basically naked. It's part of your clothing. I keep it on a clip because I'm used to leaving it somewhere. Anyway, it said, put down the cell phone. The average American spends about 3 to 4 hours each day on their cell phones. I think that's low. I think it's higher now. Sometimes the phones are needed for work. Most of the time, people are glued to a cell phone or surfing the internet or playing games, or at best engaged in intense messaging sessions about nothing important. Cell phones are remarkable inventions. We talked about how it became an invention. This is true. Giving us access to information from almost anywhere. There's no doubt that cell phones are changing the way we interact with each other and human beings. And not many of those, many of those changes are not good. I thought that was an interesting quote from the Post-Gazette, especially from our perspective as lawyers. Every client walks in your office has a cell phone. So there's any other questions? We're here. There's more cheese and crackers for everybody here, and not those that didn't show up. So
Crackers to my friend.
so
We're done.
I
Thank you.
guess that's it. Thanks for attending.
Thank you.
Thank you. Oh, and one last thing. I want to thank Lori for sponsoring this from the library. She actually brought books, if you want to look at. She researched, and the judge held it up. She's tabbed things that are in books about cell phones and where it's going on. So the judge is proudly displaying it. So Lori's a great asset to this law library. She puts programs together, and she has the materials that you might need. So thanks again, Lori.
Little late on cheese.
I want to say one other thing too. Thank you so much for that, John. Thank you too, Judge. I was amazed when I looked at pardons. Not that I'm always amazed at pardons, but the state statutes, the number of additional resources for information just after the very beginning of this law is unbelievable. From the standard PA practice summary of PA jurisprudence. Unbelievable. Don't forget to use pardons to get you started on something, especially when they have a list of all the different places that you can find specific information. Besides, also putting cases in there, which you probably know of, but they divide them into whatever the topic is about wiretapping or eavesdropping. So wonderful sources in the indexes that I had here. So thank you so much for attending. And anybody who's on Zoom, you can email me at haganl@duq.edu with your attorney number so I can make sure that you get the CLE credits. So thank you so much for attending. I really appreciate it. Thank you, John. Thank you, Laura.
Thanks, Lori.